Good afternoon to all of you. It's a pleasure to be here commencing another edition of the Chamber Talks, the webinar of the Chamber of Conciliation, Mediation, and Arbitration Ciesp, Fiesp. And this afternoon we have a very special topic, an international edition with well-known and important professionals. We have the Vice President of the Chamber, Ciesp, Fiesp, Minister Gracie Northfleet, who will be delivering shortly the opening remarks. And as our guest, we have Professor Lucas Mistelis from Queen Mary, University of London, and Sentence, who is the head of America's Dispute Section at White & Case, Hugh Carlson, who is Managing Director of Three Crowns and lecturer at law at Harvard Law School, and Felipe Sperandio, who is a counsel at Clyde & Co. I'm João Lessa, I'm the Secretary-General of the Chamber Ciesp, and I will be the facilitator of the debate today. So Minister Gracie, Felipe, Hugh, Henk, and Professor Mistelis, it's a pleasure to have all of you here, and I'm sure we'll have a most fruitful afternoon of discussions. Minister Gracie, please.
Thank you, João. It's a great pleasure for me to open this edition of the Chamber Talks. I'd like to begin by paying a tribute to one very important jurist in this country. Today is the last day, the last hearing that Justice Celso de Mello is attending. He, as you may know, he's retiring in the next few days. Justice Celso de Mello stayed at the court and was a colleague of us during 31 years. And he produced a very solid jurisprudence that will remain and for the years to come. He's a great jurist. He was one of the enlightened ones at the Supreme Court. He will always be remembered as that. So before, I would like also to, first of all, give a special thank you to all our guests on behalf of the Chamber Ciesp, Fiesp, and of our President, Justice Sidney Sanchez. He couldn't be here with us today, but he sends his best. Thank you for being here today to discuss and to share your knowledge and experience on a topic of the utmost relevance, international investment and arbitration. I would like to also to greet and to welcome the large audience that's following us on Facebook. This webinar subject is particularly important at this present moment for Brazil and for our Chamber of Arbitration. After dealing with an unprecedented sanitary crisis that unfortunately is still ongoing, Brazil is now looking to its economic effects and how to overcome this very difficult situation. So the need to attract foreign investment is paramount. Foreign investment, as you all know, is crucial in several fields of importance to the country's development and economic recovery, especially in the areas of infrastructure, industrial activities, and public procurement. But in order to attract international investors, it is fundamental to have a background of legal certainty and safety for contracts and legal obligations. Furthermore, the need to resolve disputes in an expedite and trustworthy manner points out to the adequacy of the use of arbitration for large contractual disputes, including those involving the Brazilian state in all levels, from the federal to the states to the municipalities. Arbitration is, in many cases, the most adequate means to resolve disputes involving the state or state entities. Legislation was amended in 2015 in order to allow and encourage that cases where the state is one of the parties are resolved by arbitration. Indeed, the option for arbitration has grown and grown. And the Chamber Ciesp Fiesp is a showcase for that. Last February, we were still in present mode. We were not away from each other. Last February was the last opportunity, and our chamber, in partnership with several public authorities, organized the first Brazilian Congress of Arbitration and Public Administration, a two-day event that received in our headquarters in São Paulo over 400 people from all over the country. There is today a very great interest for this subject that until recently was not much known. The Chamber Ciesp Fiesp has managed already over 30 cases involving public entities worth millions of dollars. Those cases dealt with public procurement, administrative concessions, and contracts in different sectors, such as sanitation, construction, and energy. As we look to the international side of this discussion, the experience is quite appealing as well. The Chamber Ciesp Fiesp is consistently recognized by international publications as a leading dispute resolution institution in Latin America, and has had cases involving 13 foreign different jurisdictions. Currently, around 20% of all ongoing arbitration cases are conducted in English, and our chamber is the leader in managing cases under UNCITRAL arbitration rules in Brazil. The relevance of this webinar to Brazil and to our chamber is clear. We're very happy to encourage the discussion of the topic and bringing in the international perspective of some leading practitioners. So thank you very much to Professor Lucas Mistelis, to Ank Sentence, to Hugh Carlson, and Felipe Speranjo that are here with us today. I'm sure that this will be a most productive meeting. Thank you very much, and have a wonderful discussion.
Thank you very much, Minister Gracie. And now let's proceed to the debates and to the exposition on the topics. And let's begin with Ank Sentence explaining the models for investment dispute resolution that are available. Ank, please. Thank you so much.
Thank you, João. Good afternoon, and thank you to you and Minister Gracie and the Chamber for inviting me to be with you today. So I'm going to set the stage for today's conversation and provide an introduction to the two main forms of arbitration by which disputes arising out of foreign inbound investment, as Minister Gracie was describing, into a country are being resolved through arbitration with public entities of that country. And those two main forms are, on the one hand, international commercial arbitration, and on the other, international investment arbitration. The traditional way for more than a century has been to resolve these disputes through international commercial arbitration. For instance, several very well-known arbitrations that are still being cited today in cases took place in the early 20th century between foreign investors and states regarding oil concession. One famous example, for instance, is the arbitration between Saudi Arabia and the then American oil company Aramco, when in 1954, Saudi Arabia concluded an agreement with the famous Greek billionaire Aristotle Onassis, giving Mr. Onassis a right of priority to transport all Saudi oil. Now that, of course, was not to the liking of Aramco, which had obtained about 20 years earlier in 1933, a concession from Saudi Arabia, giving it the exclusive right to explore, extract, transport, and export Saudi petroleum. Aramco initiated arbitration under its concession agreement with the state, an international commercial arbitration, and Saudi Arabia's contention that its concession agreement with Aramco only covered transport within its territory was rejected by a tribunal in 1958. Now, that's one example of international commercial arbitration. It's probably known to most, if not all of you, and it is, as we will hear in a bit more detail later from Felipe, the system in Brazil for resolution of disputes relating to foreign direct investments in the country's oil and public infrastructure sectors. So in a nutshell, in international commercial arbitration, the state or public entity involved agrees to arbitration in a contract with the foreign investor or in a concession or a license that is extended to the foreign investor. So it's a form of arbitration, and this is fundamental when we contrast it in a moment to international investment arbitration that is contract-based. There is privity of contract between the foreign investor and the public entity. As you will all know, arbitration agreements and awards in international commercial arbitration are subject to the 1958 New York Convention, which requires state parties to recognize foreign arbitration agreements and awards subject to certain limited exceptions. These arbitrations can range from fully neutral, with the seat of the arbitration located in a neutral third country, foreign language being applied in the arbitration, usually English, and a foreign national law, or sometimes, but quite rarely, lex mercatoria being the applicable law. So that's one spectrum, fully neutral, to fully local, where the seat is in the state in which the investment is made and the law and language of that state apply. Now, where on the spectrum these choices end up between fully neutral and fully local depends on the leverage of the state and the leverage of the foreign investor, and also, as Minister Gracie alluded to, the investor's risk calculus in relation to the local legal system. Does the investor trust the local system enough, or in its risk calculus, does it feel that the risk of having to go and have a seat, for instance, in the local country is low enough that it can be taken in return for the profits that are anticipated to arise out of the investment? And as we will no doubt hear also in more detail later from Felipe, the system in Brazil for disputes related to FDI into the country, so foreign direct investment into the country, is fully local. The seat must be in Brazil, Brazilian law must be applied, and arbitration must be conducted in the Portuguese language, which is of course a sign of the leverage of the Brazilian state. And I do think also, as Minister Gracie said, of the relative confidence of foreign investors in the rule of law in Brazil. Now, let's turn to the second, more recently developed framework for resolving disputes with public entities arising out of international investment. And that is, as I said, international investment arbitration, also called investor-state dispute settlement, or the acronym ISDS. Oftentimes, when foreign investors encounter bad treatment at the hands of a public entity in a foreign country in which they are investing, there is no contractual relationship with the public entity. For example, the foreign investor's investment may get expropriated. Very often in such a circumstance, there is no prior existing contractual relationship. And so the foreign investor has no contractual right to arbitration, and often also no real recourse to the domestic courts, because suing a public entity in its domestic courts as a foreigner remains not a recipe for success in many countries, and has not been one for many, many years. Now, the traditional means for resolving such disputes has been espousal by the foreign investor's home state, who could bring a claim on behalf of its national against the host state at the Permanent Court of International Justice, and since 1946, its successor, the International Court of Justice. There's many well-known cases, examples of ICJ cases, including such a mechanism of diplomatic protection. One case that may be familiar to you is the Elsie case, where the United States claimed against Italy on behalf of a US corporation. Now, while it was wonderful that there was an avenue for foreign investors in these circumstances, there were several serious drawbacks to that avenue. Most importantly, the fact that the state's decision whether to espouse a claim on behalf of its investor was really a decision of the state that the state could make in its discretion. And so the foreign investor was completely in the hands of its host state. And that all changed with the first bilateral investment treaty, or BIT, between Germany and Pakistan in 1959. And since then, the more than 2,500 bilateral investment treaties and other international investment agreements that are in force today. Those treaties allow a foreign investor to bring itself an international arbitration against the state. Here's how it works. The treaty contains a mutual offer of the contracting states to arbitrate certain disputes with foreign investors of the other contracting state, and a qualifying investor with a qualifying dispute may then choose to accept that offer at the time a dispute arises by submitting a request for arbitration in accordance with the terms of the treaty. The grounds for the claim, so the substantive claim that one can make are set out in the treaty and include things like expropriation, a lack of fair and equitable treatment, most favored nation treatment, and a few other provisions. Now, this is a pretty extraordinary thing because a private investor was confronted with wrongful behavior by a public entity in a foreign state in which it invests can bring an international arbitration claim against the state, which voluntarily subjects itself ex ante into the jurisdiction of a neutral panel of 3 arbitrators. I don't think I have too much time left, so let me quickly highlight the 3 main differences between international investment arbitration and international commercial arbitration. First of all, an international investment arbitration is always against the state, not a separate public entity, even if it arises out of conduct by a separate public entity. So one requirement is that the conduct of the public entity must be attributable to the state, otherwise you can't bring a claim. Another important difference is that the dispute needs to arise out of an investment. Now, there's a debate about what an investment means, but there's consensus that it needs to be more than a simple commercial transaction, more than a simple sale of goods, for instance. There has to be some commitment of resources to the state with the intention to make a profit. Another difference is that because the instrument that forms the basis of the claim is a treaty, not a contract, the applicable law is international law rather than national law, as I discussed before in the context of international commercial arbitration. And the final key difference is that while investor-state arbitration can be under any set of arbitration rules, a special venue that exists that is available only for investment disputes is ICSID arbitration. And ICSID arbitration is really unique because it's truly a national arbitration. It doesn't have a seat in any specific country in the world, but it's considered to be a national. And so an ICSID award cannot be challenged in the courts of any national jurisdiction. One can only bring a claim for annulment against an ICSID award in the context of the ICSID convention itself. Now, ICSID has been a real success story in terms of cases. The first ICSID case was registered in 1972. For about 25 years, there were very few cases registered at ICSID, but as of 1997, the volume has been going up every year, with a peak being reached in 2019 when 39 cases were registered. So investment arbitration, to conclude my initial remarks, has been a real success story in the past 2 decades, but it has also faced a number of criticisms, as we will now hear from you and Lucas.
Thank you so much, Henk, for your words and for sharing your knowledge. Now we'll hear from Hugh Carlson. Please, Hugh.
Thanks very much, Joel. Can everybody hear me okay? Terrific. Well, it's an honor to be a part of this distinguished panel. I'm grateful to the organizers, and it's something of a homecoming. Felipe and I were both students of Professor Mistelis in Queen Mary's LLM program about 10 years ago. The natural conclusion is that any mistakes that we should make over the course of our presentations are directly attributable to Professor Mistelis. Ankh, I'm afraid that you're out of luck on that score. So with Ankh having hopefully laid the foundation of investment arbitration, as she mentioned, I'll now turn to some of the concerns that have arisen with regard to it in the reform efforts underway. Professor Mistelis will follow on to that. These concerns aren't to be taken for granted, having been raised by both investors and states. Minister Gracie underscored this excellently in her opening remarks in the implications that addressing the concerns may have in terms of informing future foreign direct investment. On the one hand, we have countries such as Chile, Israel, Japan, Mexico, and Peru who have advocated reforms on individual or discrete aspects of ISDS, such as the development and enforcement of codes of conduct. On the other hand, we have the European Union, who on the 1st of July 2017 declared that for the EU, ISDS is dead. In hearing this, one may be reminded of Mark Twain's old quip, reports of my death are greatly exaggerated. With the benefit of the points that I will now cover together with Lucas, you'll be better equipped to decide for yourself whether or not that's the case. I'll endeavor to remain objective throughout, though of course happy to answer questions as they should arise. The order in which I propose to address this are as follows. First, I'll address some of the key concerns that have arisen and what are motivating efforts to reform ISDS both incrementally as well as more structurally. The second, I'll address some additional concerns that aren't just discussion that may be somewhat unfamiliar to Brazilian lawyers in particularly, as well as some from other civil law jurisdictions, and try to provide a little bit more insight as to those. And then third and briefly, I'll touch upon the reform efforts themselves, turning it over to Lucas to hopefully add on to that. So beginning with the concerns that have arisen, I'll look first to concerns that ISDS permits investors to challenge a state's set of measures with regard to health and environment. So for those of you who subscribe to The Economist magazine, you'll have perhaps seen from an article 3 days ago that investor-state dispute settlement provisions are being blamed for impeding government action on the environment. The Economist writes that the EU is concerned that because of ISDS provisions, one well-known treaty, the Energy Charter Treaty, is threatening the climate ambition of the European Union domestically and internationally, and that this was captured in a letter signed by nearly 150 members of European and national parliaments. The worry is that if governments force polluting industries, notably fossil fuel stations, to close down, they may face arbitration claims, including compensation bills that may attach to that. Other concerns have arisen as well on this point with regard to what's been described as regulatory chill. The governments might be deterred from passing laws for fear of ISDS repercussions. One example that has been raised is with regard to New Zealand announcing that it would delay introducing rules about cigarette packaging until a claim against Australia by the tobacco manufacturer Philip Morris was resolved. Philip Morris ultimately lost that case. In response, those note that in the decades of investment treaty arbitration, there really aren't any reported cases where a rogue or errant tribunal wrongly awarded compensation to an investor on this basis. There are some that may be debatable, but even among those who would identify this as being a key concern, there aren't any that really rise to this level. And they note in support of this that the cases relied upon by critics, which tend to focus, for example, on two Philip Morris cases brought against Australia and Uruguay, both saw the investor lose. in those cases. And in that, to the contrary of what critics may suggest, that this reaffirms the merits of the system. The supporters of the system have also argued that on net it actually has a better track record than courts in terms of its performance, while at the same time acknowledging that regulatory chill can exist. There just may be better ways to address it than by a whole-scale reform of the system. The second point that has come up, the second concern, is with regard to the consistency and predictability of investment awards. So critics have flagged that there have been inconsistent outcomes in two respects. First, with regard to how treaty standards have been interpreted by tribunals. So, for example, what constitutes fair and equitable treatment, which is one of the standards that arises in many of the bilateral investment treaties to which Ankh referred. And then another instance in which there's been some inconsistency is how two tribunals have resolved the same set of facts with slightly different parties. That type of inconsistency arises much less frequently, but it has come up. Those who respond to this have suggested that concern over these inconsistencies may be a little bit overblown. And they do note as well that the existence of these, and they do concede that they exist, may be a strength and not a weakness. That is, that in court systems around the world, bad decisions are usually drowned out over time by good decisions. And occasionally a good dissent will rise and represent the majority view within that jurisdiction. A system in which splits are not permissible, in which those types of dissents are discouraged, could arguably diminish the likelihood of evolution in jurisprudence and in case law, rendering that system fragile, somewhat static, in a state of semi-permanence. The response to this from those that identify it as a weakness note that investment arbitration is simply too slow to address these types of bad decisions as they were, that with a case potentially taking 4+ years on average, that while in theory that may be a good idea, in practice it's not happening quick enough, and there need to be additional protections in place in order to address it. The third concern that has come up is with biased arbitrators. That critics of the system will flag that, as in commercial arbitration, as Ankh touched upon, arbitrators in investment arbitration are often party appointed. This means that a tribunal of 3 arbitrators will often see each party appointed by one party, and the third appointee or the third arbitrator being by agreement of the party appointed arbitrators or by an arbitral institution, for example, although there will be exceptions to that. Critics have described this as constituting the original sin of international arbitration, that this leads to a system in which adjudicators have an incentive to perform in a way that rewards the possibility of reappointment as opposed to achieving a more just outcome when those two poles are in tension. It can lead also to conflicts of interest, potentially resulting in unjust outcomes. Those in response will note that there's little evidence that this has taken place, and will question who is better placed to appoint arbitrators, if not the parties themselves, flagging that one of the factors that will inform appointment is familiarity with the subject matter, with the applicable law, someone who will be well positioned to resolve the dispute, and that for an institution, for example, to be in the position to serve in that for all 3 appointees could run the risk of mistakes being made with regard to what's taken into consideration. Those who would respond to this criticism have also raised facts yielding that in investment arbitration, 35% of cases have sided in favor of states, with 29% in favor of claimants. I understand that these figures are of last year, not this year. So there are, again, arguments on both sides there. I'll turn now briefly to some items that may be of interest to those from a civil law background, in that they're a little bit perhaps less familiar. The first is with regard to what are known as amicus curiae. This is a term that originates in Roman law and refers to a participant in an adjudicative proceeding who is not a party to a dispute. They may be permitted to make submissions or otherwise take part in the proceedings, but for example, damages wouldn't be claimed against them. In the investment arbitration context, they're often non-governmental, public interest organizations, and they often, almost always in fact, would seek to submit some type of submission on behalf of a state as opposed to an investor. In the investment context, there is some uncertainty as to whether tribunals should have the authority to permit for amici, as they're called in the plural, when the underlying legal instruments are silent on the issue. And if they are awarded that authority, if they do have that authority, when should they? Just because they have the authority doesn't necessarily mean that they should be making use of that. And what are the procedural considerations that should inform their participation? The underlying point that is raised in part is that by permitting amicus submissions, the duration of the dispute can be extended, costs to the parties can increase, and this is obviously not necessarily consistent with the interests of the parties, and at least one of the parties in having submitted to arbitration in the first place. And so efforts are underway to consider the best approach for amicus submissions, in part because, as supporters will argue, it provides tribunals an opportunity to understand issues in the dispute that may not otherwise sort of be put before them in the same way. The second issue is with regard to security for costs, which is an order by a tribunal requiring usually a claimant to provide some type of payment in the event that its claim is ultimately unsuccessful, the payment constituting the security. This is relating only to legal fees and expenses arising from the defense of the claims, and it doesn't extend to security for example, a counterclaim award on damages. It's only appropriate, to be sure, when the principle of cost shifting arises, which it can in the investment arbitration context. This again is an issue that is receiving some treatment on both sides, as reformers are criticizing how infrequently it's used, while others are saying that it introduces practical constraints on the ability of a claimant to proceed with legitimate claims. The third small point I'll raise, and it's to be sure not a minor point, but for purposes of time I'll constrain myself, is with regard to third-party funding. It's a financing mechanism wherein a third party, for example, it can be an insurance company, even a law firm in some cases, will finance at least part of the proceedings in exchange for some of the return, a percentage of the award on damages. This is an item that is squarely within reform discussions presently underway, with concerns being raised in no small part by states that it can permit for a greater number of frivolous claims, and that it can also permit for parties to play a role in the process without disclosure, potentially introducing conflicts of interest. Those in favor of third-party funding have noted that, on the other hand, it permits for access for justice. The parties that may not otherwise have access to bring a claim with the benefit of that financing are able to. Lastly, and very briefly, and then I'm just about out of time here, I'll note that these concerns are now crystallizing in reform discussions that are very much underway. UNCITRAL has in its working group 3 sessions that are being undertaken in order to evaluate, in sometimes very heated conversations, the merits of different reform proposals and the concerns that I've just addressed and how seriously they should be treated. One of the major proposals that has been put forward by the European Union is the Multilateral Investment Court, with its overall objective being to set up a permanent body to settle investment disputes. it would see judges that are tenured, qualified, and receiving remuneration, and for that reason, the concerns for impartiality and independence would be more achievable as per the advocates of the system. There would also potentially be an appellate mechanism that would feature in this, as well as greater transparency. Critics of the court have raised a number of concerns with regard to it, one of which being the selection of these judges, in that investors are unlikely to have a meaningful role in it, potentially resulting in decisions that are skewing consistently favorably for the states who are ultimately responsible for creating the court. And the result of that will potentially see alternatives to an investment court as investors try to grapple with the new environment. I certainly have more that I can add to this, but in the interest of time, I'll pause there. And again, happy to take any questions. Thanks very much.
Thank you so much, Hugo. It was such a broad overview of the topic with so many important aspects. And now we will have the pleasure of hearing Professor Mistelis, who will be following on this focus on the general aspects of international investment arbitration. Professor Mistelis, please.
Thank you, João. Listening to the previous speakers making excellent presentations, I find that my own might be a bit irreverent or provocative, and I will try to contain that sort of temptation. Interestingly enough, we've been speaking about sort of how the various options have developed for investors, and also about this concept of the legitimacy crisis of ISDS. And it's a very interesting point to try to identify when can one crystallize the beginning of that legitimacy crisis. And there were effectively two different starts of this legitimacy crisis. One being a movement primarily from non-governmental organizations, or civil society perhaps would be a more appropriate term in this sense, and indeed journalists, which goes perhaps about 10 to 15 years back. And the idea was that they have identified as the key concern about ISDS that is a system that has been developed by law firms to some extent, particularly large law firms, for the benefit of multinational enterprises. And effectively what we have seen from the beginning of the 1980s is the reduction of the role of the state as an actor of international law. International law was now driven by cases brought by corporations, sometimes individuals, and the states have cornered themselves in being in a responsive state. So that was one side of the origin of this legitimacy crisis, and is ideological, is a largely an anti-globalization rhetoric. It doesn't matter perhaps where one stands from in terms of globalization, but for example, this morning the SUS have decided to put on were from Brazil, my tie is from Italy, my shirt is from the UK, and my glasses are from France. So in a very simple example, and most likely the toothpaste I've used was in an American company, but God knows where it was done, and so on and so forth. So we live in a globalized world. So that particular agenda seems to be a bit almost naive. But the second part of the debate has gone, perhaps, is a bit closer to about 6 or 7 years ago, when a number of cases were brought not against emerging economies or developing countries, but have been brought against developed countries. We had the first cases against Germany, particularly a case called Vattenfall. We had a number of cases brought against Spain, and a couple of other cases that were sort of mushrooming against sort of developed countries. Philip Morris is one of them. There have been, of course, a number of cases against the United States, but the United States has never lost an ISDS case. So and that prompted a second ideological sort of concern about ISDS. On one hand, we have almost a left-wing rhetoric, sort of And on the other hand, now the new model is almost a nationalistic populist rhetoric against ISDS. So the two extremes, the left and the right, unite against the system. One could argue that if that's the case, that perhaps something good there in the system, because if the extremes sort of take that movement. But the reality is that no system is perfect. And ISDS is a system which is based on international investment agreements, and the owners of these agreements, the creators of these agreements, are states. And states, of course, have the prerogative to change these treaties. And in that context, there have been a series of attempts by a number of international organizations to look at the question of the reform of ISDS as we knew it. And these reforms are taking place primarily now in UNCITRAL, the United Nations Commission on International Trade Law. It's the first time that they go to a purely public international law subject. That's Working Group 3. There are reforms underway within ICSID, the International Center for the Settlement of Investment Disputes. But there are also a lot of work that comes from other international organizations, from the OECD, from UNCTAD, from the UN Conference for Trade and Development. A lot of these reforms are seen to be primarily procedural reforms. However, distinguishing between substance and procedure is not always very, very easy. So the security for costs that Hugh has referred to is most likely a procedural issue. Third-party funding, my concern about third-party funding is slightly different. It's not whether it puts an investor in a better position than the state, and the investor being able to spend more money on the dispute. In my experience as an arbitrator, I sometimes am concerned if I know that one party has been funded by an organization for the very simple reason that these organizations are not sort of charitable. They undertake such an investigation of the case before they agree to fund, and they fund cases which have in excess of 60% chances of success, perhaps some of them even 70% chances of success. So that could be perhaps a bit skewing the way the tribunal sees the case when a party has gone through a funded process. So, but a lot of these matters, a lot of these reform were what we will call low-hanging fruits. One of them, and Minister Gracie was actually very good in describing that, and also in our pre-official sort of discussion, is the concept of transparency. I think if you have concerns about civil society, one of the responses is increasing transparency to the system. Transparency in the proceedings, transparency in the appointment of arbitrators. Of course, we have not achieved the maximum level of transparency, but we have achieved a significant level of transparency, and there are many investment treaties that provide, or free trade agreements that provide for public hearings, and that popularization of ISDS has been very critical. One of these examples is CAFTA, the Central America Dominican Republic Free Trade Agreement. Of course, unlike Brazil, most of the CAFTA hearings have no much viewing. So in the beginning, they were booking sort of lecture theaters so that people can go and sit and attend before they go broadcasted on YouTube and other channels. But the uptake was limited. But transparency is important, and it's important that we have it there. And allowing some access to non-disputing parties through amici, curiae, and all of that is also a very important aspect, and that's actually an aspect that develops significantly. The third, what I will call low-hanging fruit, is the concept of investor-state mediation. A way of managing the dispute, not allowing a dispute to escalate, and that applies for both commercial but also investment disputes, is promotion of mediation. And investor-state mediation is being promoted systematically at this stage. It hasn't gone very far for the very simple reason that if the settlement between an investor and a state is to the effect that the investor is being compensated for part of what the investor has expected to get out of the arbitration, there will be very, very few people in the government or in the civil service that will be prepared to sign the settlement agreement. and the process of getting that approval is far from complicated. At the same time, we do have the experience of a number of jurisdictions. I will mention particularly Egypt, but also Argentina, where in a number of occasions, the states have entered into fruitful negotiations with the investor, and they have settled the case. Sometimes before the arbitration has gone very far, sometimes even while the arbitration has gone already very far, but try to avoid enforcement proceedings. And the other, of course, problem is the tribunal selection and appointment. It has been high on the agenda of lawyers and dispute resolution lawyers, the need to promote diversity, the need to allow a broader pool of arbitrators to be selected, and to ensure that these arbitrators are restricted in the way they have received repeat appointments. For some people, it might be shocking, or perhaps akin to an investment court system, to know that there are individuals who have been appointed in excess of 100 cases in investment disputes, and we only have about 1,000 cases altogether. So if an individual has been, and that network has been done by a number of very sophisticated analysis by academics, so some people have, perhaps a handful, have really influenced jurisprudence more than anyone would have done otherwise. But in addition to that, there's also a discussion about an advanced code of conduct, which has been drafted jointly by Ancestral and ICSID, and that's certainly something that will go very, very far. So the reform touches on a very large range of issues, and a lot of that is in the right direction. There are, however, a number of issues which are a bit less easy to fully understand. For example, the concept of counterclaims, the ability of states to bring defenses, affirmative defenses against an investor, is seen in this week that Ancestral is meeting as being borderline substantive procedural matter, or certainly is borderline substantive jurisdiction and procedural matter. And some treaties are clear that there's a possibility there, but there have only been 17 cases in the last 10 years where states have brought counterclaims. And that would require a treaty reform rather than a document that is produced by Ancestral. The question about shareholders' claims, independent from the company in which they have invested, and reflective loss, that's again a borderline topic. My feeling is, and I will perhaps stop here with my initial comment, is that my personal view is that we cannot reform ISDS by introducing a procedural reform only. And it will be quite important to sustain a system of multilateralism and a system where we'll have a more comprehensive investment agreement which covers both substance, procedure, and indeed jurisdiction. And I think with that, we will conclude my introductory statement. Thank you.
Thank you so much, Professor Mistelis, for this overview on this system and the needs of reform. Now let's go to Felipe Sperangio, the Brazilian representative of the group here. So given a perspective of Brazil, who's quite a unique case or a special case when dealing with international investment. Felipe, please.
Thank you, João, for organizing this seminar and for choosing such a timely topic for Brazil. Many thanks, Justice Grace. Ciesp Fiesp is undoubtedly one of the main arbitral institutions in the Americas, always rendering excellent and reliable services. Arbitration involving the public entities has been developing gradually in Brazil. To a large extent, this development has been driven by key industries, such as energy, natural resources, and infrastructure, which require heavy private investments to take those projects off the ground, and require private investors to enter into contracts with public actors. If it were not for the recent pro-arbitration stance adopted by public entities, foreign investors would be left with Brazilian courts. this would be somewhat unattractive because foreign investors usually do not possess sufficient information to assess the degree of impartiality and sophistication of the national courts of any given jurisdiction. With that in mind, I'm going to talk you through the Brazilian model to resolve disputes with foreign investors, the peculiarities of this model, current investment agreements entered by Brazil, and whether they provide for dispute settlement, and in the end, opine on whether Brazil should join the Exceed Convention. There is no legal framework in Brazil specifically designed to protect foreign direct investment. Brazil has not signed the Exceed Convention and has not ratified any bilateral investment treaty providing for investor-state dispute settlement. Does it mean that investors are left without any legal protection, or that they are of disputes relating to the foreign investment in Brazilian courts? No, they are not. Brazil has developed a model to resolve disputes between public and private parties, which is entirely based on commercial arbitration. In fact, Brazil is in the process of writing a new chapter in its legal history in which public entities and the government on a federal, state, and city level has become comfortable in arbitrating contractual disputes and are in the path to become frequent and sophisticated users of arbitration. Having said that, we need to avoid the misperception that the Brazilian model is alike or similar to the traditional investor-state dispute settlement system. As the Brazilian model only allows for commercial arbitration, three main distinctions deserve attention. Anki already touched on some of those distinctions, and I will partially emphasize what has been said. These distinctions are consent, how and whether to qualify a private party as a foreign investor, and the laws that will govern the parties' relationships and results. In relation to consent, the public entities give their consent to arbitrate on an individual basis by entering into a contract containing an arbitration agreement. It is different from the traditional investor-state dispute settlement system, in which a host country offers a general consent to any foreign investor qualified to claim under a particular international investment treaty ratified by that country. In relation to qualifying someone as a private investor, the legal framework does not distinguish domestic and foreign investors. Everyone will be treated alike, regardless of nationality or whether the private party is an investor or not. In relation to the laws applicable to the parties' legal relationships, the arbitral tribunal will resolve the dispute according to the substantive law of the contract, as opposed to relying on public international law. Moreover, many public actors are only allowed to contract under Brazilian law. By combining those distinctions, the investors are left with commercial arbitration in lieu of investor-state arbitration, cases primarily focused on allegations of contractual breach, as opposed to allegations of regulatory misconduct, and arbitral tribunal applying Brazilian substantive law in lieu of public international law. The Brazilian model is a welcome development, despite its potential limitations. Let's take, as an example, energy and natural resources industries. These usually need to attract foreign direct investment to build up expensive projects and related infrastructure. Differently than other countries, in Brazil, oil, gas, and subsoil resources belong to the state, and only the federal government controls how private investors participate in those projects. This requires the federal government to grant concession contracts to private parties to produce energy and mine minerals. So private investors in those projects will invariably enter into contract with public actors. It is common sense and understandable investors prefer not to resolve disputes against a public entity in the national courts of the country in which that public entity is constituted. What if the judges of a particular country are biased in favor of their own nationals, even if unconsciously? What if the government of a particular country seeks to influence its national courts? Against those risks, it has been long accepted that the possibility of resolving disputes in a neutral venue, ideally by arbitration seated there, or at least outside national courts of the host country by way of arbitration, makes a jurisdiction more attractive to foreign investors. The Brazilian public administration understood that resolving disputes outside in the national courts, it's in the interest of both the government of a country and the investor. The former needs to attract private investment, the latter needs assurance to invest. What are the peculiarities of arbitration involving Brazilian public entities? There are many, some of which Anki helpfully has already touched upon. In my view, the main is the limitation to party autonomy. The Brazilian arbitration law grants full party autonomy to select the laws and rules applicable to a legal relationship and to tailor dispute resolution mechanisms. There are only two minor arbitrations involving the public entities, which are the dispute must be resolved at law as opposed to by equity, and the arbitration proceedings must be subject to a certain degree of transparency. However, Brazil has been enacting several laws regulating certain types of contracts with the federal administration or certain industries. These laws go a step further and also regulate arbitration with public entities, in many cases reducing the party autonomy provided in the Brazilian arbitration law. Many of these laws provide that the contract must be subject to Brazilian substantive law. Brazilian law applies to the arbitration agreement, and the arbitration must be seated in Brazil. In essence, we are talking about a foreign investor taking part in a domestic arbitration. In fact, the only law that mentions international arbitration expressly is the sector law for the oil and gas industry. Many of these laws also address objective arbitrability by listing the type of disputes that can be submitted to arbitration. This is another potential limitation to party autonomy. While preparing for this conversation, I have come across to about 20 laws addressing arbitration with public entities. These recent and numerous laws have ignited different views. In my view, it is unnecessary from a legal perspective and unhelpful from a commercial perspective to overregulate commercial arbitration involving the public administration. And I'll give 3 reasons for that. Firstly, there is a correlation between the level of ease of doing business and the level of investment in a country. The proliferations of laws create a complex legal framework for the foreign investor to navigate. And overregulated markets attract fewer players. On the other opposite of the spectrum, a streamlined legal framework reduces transaction costs, creating an incentive to invest. Secondly, the full party autonomy granted by the Brazilian arbitration law should be regarded as an asset to the public administration, allowing it to adjust its contractual positions according to the features of each transaction and to the health of the economy. This is beneficial during an economic downturn in which public entities could make temporary concessions to swiftly increase foreign direct investment levels. Thirdly, the propagation of laws addressing arbitration with the public administration may cause confusion. They may give the wrong interpretation is only permitted where there is a law saying so. Now we move to the current investment agreements adopted by Brazil. They are translated as cooperation and facilitation investment agreements. Brazil has entered into 17 of those agreements in the past 5 years. They are designed, of course, to encourage the flow of capital between the signatory nations. I would expect a clear and efficient dispute resolution mechanism giving assurances to the investor. However, these agreements do not allow the foreign investor to start arbitration against the host country on its own initiative. Instead, the investor must convince its home country that it has been injured by the host country, and then convince its home country against the host country via state-to-state arbitration. It is more likely a diplomatic protection dispute resolution mechanism that actually bites. I'm not aware of any arbitration arising out of these agreements. And arguably, the foreign investor is better served resorting to commercial arbitration against Brazilian public entities. Lastly, I will give a humble opinion on whether Brazil should become a member of the Exceed Convention. In my view, it should not, because by signing it, it would likely bring more financial harm than benefits to the country. Exceed released its statistics for 2020, showing that 32% of the cases come from South America. This is a disproportionately high percentage of cases when you consider the level of foreign direct investment in the region, or the GDP, or the size of the population, or any other rate. So what's the explanation? It has to be related to the way that politics are done and how countries are managed in South America. And Brazil is no exception. The way in which Brazil has been managed would invite a tidal wave of investment arbitrations against us. So this view is not based on the flaws of the system for investor-state dispute settlement, which is not a perfect system. Instead, the view is based on the opinion that politics and public management in Brazil would have to substantially mature and evolve before the country is ready to grant to countless present and future investors the right to arbitrate a wide range of regulatory misconduct from its public authorities. There are other means to increase foreign direct investment that Brazil could focus on. Brazil is home of a 210 million people consumer market for the goods manufactured in the country, and it's blessed with natural resources. The focus should be on improving infrastructure to produce and distribute goods. This includes reliable and affordable utility services, suitable roads, railways, storage facilities, and ports. The country would benefit from a more capable and trained labor force, which requires public investment in education. And putting aside arbitration for a while, Brazil would benefit from a more reliable and predictable legal framework, including a simplified tax and labor laws, less bureaucracy to open up and close down businesses. Commitments to certain standards for protection of environment impact also and nowadays in the influx of FDI, and they also should not be downplayed. To conclude, no ex-city or BITs providing for investor-state dispute settlement, but a lot of homework to be done on different fronts. Thank you, João.
Thank you so much for explaining the Brazilian scenario and its peculiarities. But I would like to commence in our debate to draw upon your last issue that relates to ICSID and the Brazilian position. And actually, it's not only ICSID. In many international conventions, Brazil chooses sometimes not to be part of them for one reason or the other. And the Latin American case with ICSID is quite interesting as well. As you pointed out, many cases they go against the countries in the region. So this is a hot topic, attracts attention to what extent it's actually helpful to the countries to be part in this convention. So what I'd like to hear from all of you, so I'll actually open the question, is if actually being part on ICSID it's something decisive to attract foreign investments. I know this is debatable, but many countries actually do quite fine without being part of such a convention. So I'd like to hear your comments on that.
I'm happy to start on this question. The last time I was at Fiesp, which is a few years back, perhaps even as many as 10, there was a speech delivered at the time by Francisco Rezek, who was advocating that Brazil should join ICSID. One perhaps thing that one has to say is that, first of all, ICSID itself does not decide matters. It's ICSID tribunals that decide matters. And joining the ICSID convention does not provide consent to investment arbitration. So being a member of ICSID is a manifestation to the world that you become part of this, if you wish, international treaty, which has nearly 155 states, 160, without any direct consequences, and you can inform how new rules are going to be looked after. Yes, there are many cases against Latin American states. There's 50+ cases against Argentina. There's a very large number of cases against Venezuela, Bolivia, Ecuador, but there are not many cases against Uruguay or Paraguay. There are not many cases against other states. So a lot of the investment cases have to do with a particular moment in a state's history where financial measures have to be taken. Some of these decisions are entirely political. Some of them are entirely financial. So the Spanish renewable cases are financial; they're not political, and everyone understands them as being such. So I would rather take a different view on this matter than Felipe.
Fantastic.
I would too, and to echo some of Lucas's comments, I don't think it's fair to say that 30% of the cases are against Latin American states, and so there's a specific lack of anyway, there's a specific attack or something like that against that region. There are a number of cases now against Spain and Italy, as Lucas mentioned. There are a number of cases against Eastern European countries. And I would say the cases in Latin America are in jurisdictions where something did go terribly wrong in the last couple of decades, and as Lucas already also mentioned. Also, I guess to the point of we shouldn't have ICSID arbitration because our house is not in order. You can also see the contrary argument, of course, that there's potentially a need for ICSID arbitration to either because the house is not in order and investors need some form of protection, or ICSID may help in a way to get the house in order. Those are two different points. I think to the first point, is it necessary? I would agree Brazil right now doesn't need it. Because it's able to attract foreign investment with the system that it has. But that may change. leverage does change. I talked about leverage in the beginning, and can you get people to come and take the risk of fully subjecting themselves to the local system? That calculus may change over time, and also may change depending on developments in the country. So I would agree that under the current constellation, acceding to a more international way of resolving disputes is not necessarily to attract foreign investment. That doesn't mean that it will always be the case. And then to my second point, that maybe exit arbitration does sometimes help with improving the way things are done in country. I do think there's truth to that. I do represent a number of states. These cases are taken very seriously. And I do think a claim like that, when it comes, may help and very much propel the states to look internally whether the way they are doing things is right, and so help in certain ways with legislative and other reform to bring certain practices more in accord with what are maybe considered international standards.
I might add just one additional point to what Lucas and Anke have helpfully contributed, which is from the perspective of outbound FDI from Brazilian investors looking abroad. I've just over the course of this pulled up the OECD data, and I see that over the last couple of decades, perhaps unsurprisingly, outbound FDI from Brazil has gone up considerably. So one point to bear in mind, and obviously that would have to be broken up. Where is it going? What industries, et cetera. But just assuming for a moment, if you will, that additional protections could potentially protect that and facilitate it, that may be of interest and certainly deserving of consideration in the context of whether or not it makes sense for Brazil to accede the exit convention and begin looking to BIDs to protect those investments.
Fantastic. Also, Felipe, in his speech, he said about some features, especially on sectorial legislation concerning arbitration with state entities in Brazil, that would limit the party autonomy on choosing certain aspects of arbitration, such as the need to the proceedings to be in Portuguese, or the need to Brazilian law to apply. The question I would put you, and I would like to hear from you, is that bear in mind that the way public contracts are done in Brazil, they go to different sectors, so you have different entities and bodies negotiating those countries. If it's not a fair way of the law just to set the standards when normally the defense of the state is done by public lawyers, so these people, they're actually in a career and working as lawyers for the state, so the need to be in Portuguese would have to do with that. And arguably, as the contract would be in Portuguese if the object is to be performed in Brazil with a Brazilian entity. If those are not, instead of a limitation to party autonomy, in fact, a regulation of how Brazil itself approach those contracts. Felipe, I'd like to hear you on that, because I thought interesting your view on the point.
And you're right, João. The reason given by Brazil to impose those limitations in its arbitrations is because the defense has to be done in-house. And it would make sense to be in Portuguese and under Brazilian law. But that potentially has a cost to the transaction. A contract, especially a sophisticated contract, is highly bargained by the parties. And the concessions the parties are willing to make, or the requirements that they are not, they have an impact on the price of the contract. So from the point, my approach to the question is, should the Brazilian public entities retain full part autonomy and in certain circumstances agree to a law? It's not much an issue because the arbitration can be bilingual, and that has happened. it's more expensive, but it has happened. So to retain that full party autonomy, in my view, it's an asset and should be kept. And I'm not advocating here that in every single case, Brazil should concede to have a foreign law governing its contracts. But if Brazil wants to impose the rules of the games and it's not willing to concede anything, it will pay more for its services or for the products that it's purchasing, because whoever is on the other side will have to adjust the contract price according to those requirements.
Fantastic. Does any of you want to comment on that?
I mean, not much, just it was interesting to hear the argument about the defense, which of course, defense needing to be done in-house, which of course understand to some degree. I just note that other states where there is an agreement to conduct proceedings in a foreign language do have in-house people that are capable of conducting disputes in English. Now, I understand you wouldn't be able to have that at every public entity in Brazil, and so it would have to be some coordination and some general office in the state that would be, have in-house people that can handle these cases. But it is something that, again, if there were a need to overcome it because of lack of attraction of foreign investment or the transaction costs that Felipe was alluding to, it is something that can be done. I mean, you both are talking here in English. There are many capable legal practitioners in the country that would be able to conduct proceeding in English.
Fantastic. We actually have one last question from the public that I would like to bring to your attention. And it's from Sonia Cecilia Paz. And she's asking if the Brazilian arbitration model regarding investment reflects a protectionist international commercial stance that Brazil sometimes took. So, as I understand, the question is if Brazil is protectionist even in the way it's implementing arbitration.
There's a bit of a risk in replying to this question because it's loaded politically. It does not manifest necessarily an economic protectionism as such, but there are elements of protectionist models that one can see. For example, if you restrict that the arbitration has to be conducted in Brazil and in Portuguese, that means investors cannot use their home lawyers, but they have to use local lawyers. And that's something, for example, that a lot of local lawyers would not oppose to. It has also the result that it develops arbitration in Brazil. It has a positive spillover effect. But I think if the terms of investment are clear, and that's what the risk that an investor has to assume in order to invest in Brazil, and as you say, it's a big economy, can attract domestic and foreign investment. That's perfectly fine. Now, there are protectionist elements. The answer is yes.
Good. Does anyone want to comment on that? You.
Well, I'd be inclined for Felipe too, as I'm neither a Brazilian lawyer nor adorned with a Brazilian suit. I'm not as well placed as those two, of course, Ankh as well. But I'll remain quiet on this one.
Just to follow on a point, an important point that Anki made on her presentation, the investor state situation is national. So the award is not linked to a particular jurisdiction. And Brazil, on the other hand, as it has chosen to commercial arbitration model, the seat of the arbitration will grant exclusive jurisdiction to the national courts of the seat to review and hear, setting aside proceedings over that award. So the foreign investor that does not know Brazilian courts would be fully comfortable to end up in the Brazilian courts if things go wrong in the first place that they wanted to avoid. And there's nothing wrong with the Brazilian courts, but that uncertainty, those questions, they raise the transaction costs. That risk has to be priced, and it goes in the final bargain of the parties. And it's in the interest of the Brazilian taxpayers that Brazil reduces its transaction costs.
Yeah, I mean, there's no doubt that ultimately potentially help ending up in the Brazilian courts is a serious consideration for foreign investors and represents transaction costs. I agree. I do also think there is a protectionist streak, and that's the choice that the country has made so far. It feels it's able to attract enough foreign parties interested to come, and it's willing to accept the transaction costs. Hopefully those are conscious decisions, because they are not always, but if they are, that's a valid choice for the state to make, and that choice again may shift over time.
Indeed, fantastic. So, well, we had a very good webinar and discussion, but now we need to finish it. I want to thank so much all of you, Felipe, Hugh, Henk, and Mr. Ellis, for being here with us. It's a pleasure, and I am thanking you on behalf of the Chamber, Ciesp, of course, and also of Minister Ellen Gracie, who had to leave us due to another engagement. And I want also to thank all of you who have watched this webinar. Please do follow our social media and look on our website. We have over 10 webinars now available on different topics. It's always a pleasure to be with all of you. This was another edition of the Chamber Talks, the webinar of the Chamber Ciesp. Thank you so much to all of you.